Good morning, everyone. Today I welcome you to Avoiding Negligence Claim Complaints when Dealing with Due Diligence by Ian Quayle. It's great having you guys on board. It's fantastic to see many conveyancers, property lawyers on this webinar. I'm really thrilled to have you guys here. My name is I'm Bharti Buva from Whitefield Legal Services, having been in doing searches for last 20 years. I'm the Whitefield director and the founder. My passion has always been about the more than just data. It's about building relationship, ensuring that you, the legal profession, have a reliable support you need to do your job effectively. So today we're going to just talk a bit about Whitefield Legal. At Whitefield Legal, we understand the pressures that you face. That's why we specialize in providing high specialized searches with difference. Speed is our main thing, making sure that the searches you get is correct. Personal services, no call centers, and trusted by compliance with search code and search code and PCCB, which is the industry compliant body now. And finally, we fully regulated. I'd like to introduce Ian Quayle.
Hi, hello, hi Bharti.
Hi, Ian. Ian's been doing seminars for last 12 years, but he's been in practice for 25 years doing law, property law. And I'll let you introduce himself, exactly what he does and how he does it. And it's a great pleasure to have you, Ian.
Thank you, Bharti.
Doing this for us.
Thank you very much. Thank you. I'll put my slides up if I can. And they should be able to see. So welcome to the presentation. I'll get rid of that. Get rid of that. What I'm going to do in the next sort of 60 minutes or so is share with you my views with regard to avoiding negligence claims and complaints and exploring due diligence. First of all, a massive thank you to Bharti and Whitefield for allowing me to do this presentation. Do have a chat with Bharti if you are not an existing customer of Whitefield, so that she and her colleagues can explain the services that they can provide. And if you are a client of Whitefield, then do talk to Bharti and the team just to see what's happening with regard to developments, etc., with regard to their service. As far as I'm concerned, if anyone that hasn't had the misfortune of listening to me speak in the past, I qualified as a solicitor a long time ago. I started off my life as a commercial property lawyer. I've established 2 residential conveyancing teams, and for the last 20 years or so, I've done presentations up and down the countryside talking about all manner of issues with regard to residential conveyancing. I do lots of work for professional indemnity insurers, looking at claims and what goes wrong in the conveyancing process, as well as lots of consultancy work, talking to firms about what is or isn't good practice. And the purpose today is to share with you my views with regard to due diligence and what can cause problems and issues. So going on from that then, as far as the starting point today, there are some useful websites, which hopefully you can see on screen there. All of these websites are free sites to access, other than the Property Litigation Association, which is a subscription service, and our own subscription service called Property Law UK. If anyone is a client of Whitefield and they are interested in subscribing to Property Law UK, we can offer them a discount. So if you talk to Bharti and she then contacts us, we can ensure that you get a discount with regard to the subscription service that we offer. The other sites, if you're doing leasehold conveyancing work, the Leasehold Advisory Service is a must as a site, as is the Leasehold Knowledge Partnership. If you haven't seen the RICS Consumer Guide to Survey and Valuation, will you please have a look at it? It is an invaluable resource For anyone doing residential conveyancing, of course, you should be advising clients of the need for survey or valuation, and the RICS Consumer Guide to Survey and Valuation is a fantastic resource in that it explains to clients the various types of survey and valuation the client can obtain. As far as Leasehold Knowledge Partnership is concerned, you're probably not familiar with that, but that's a site that's really useful when you're dealing with issues or problems associated with nasty landlords and nasty leases. The other site you probably haven't heard of is a site called Property Protocols. This is a site in which there's a boundary dispute protocol. Whenever you're dealing with boundary problems, neighbour disputes, or anything of that nature, Property Protocols has a lot of useful information that's free to access about dealing with boundary issues and boundary problems. I recommend it to you if you haven't seen it already. I want now to talk about some issues with regard to residential freehold transactions. Before I do that, a bit of good news. Professional indemnity insurers are telling me that claims against residential conveyancers have fallen. The number of claims have fallen by 6%, which is good news. That shows us that residential conveyancers are getting the process right and they're not doing anything wrong, or they're not doing things as wrong as perhaps they have in the past. So there has been an improvement with regard to numbers of claims, and that as a consequence of that, there are more insurers willing to look at conveyancers and to insure them. So the professional indemnity market for residential conveyancing has softened as a consequence of there being fewer claims, which is good news. The bad news is that negligence claims are still being made, and therefore we need to look at what's the sorts of things that are causing claims, which is what I do on the next slide. So what causes claims in residential conveyancing? Firstly, planning issues. There's an important point to note as we sort of drift down the slide and the bullet points that I mentioned, A to F. Generally speaking, negligence claims arise from a failure to do simple things well. And it's important to understand as a residential conveyancer, unless you hold yourself out as an expert, you're not an expert with regard to planning matters or environmental issues. You're only an expert with regard to issues associated with title. It's therefore important to understand and appreciate that when we're talking about failing to advise or failing to check, the point here is that you're failing to indicate to a client the existence of an issue or a problem, and then suggesting to the client what steps or measures you can take, what steps and measures a third party could take, or what steps a client could take in order to identify the extent of the problem or the extent of the risk. So bearing that in mind, let's just go through one or two of the points that cause claims on this slide. Failing to advise fully on planning restrictions. You are required as a residential conveyancer to indicate to me, assuming I'm a client, as to the current planning status of the property that I am acquiring. So you should be explaining to me what the current planning permission status is of the property. If there are any planning restrictions or planning conditions, they should be drawn to my attention as well. However, if there are issues with regard to enforcement action, if there are issues with regard to what I want to do with the property, then we should be advising our client either to consult us for expertise with regard to planning, if we hold ourselves out as being planning experts, or referring the client to a planning consultant, or indicating to the client that perhaps if there are planning issues, the client could take them up with the relevant planning department themselves. Or, for example, where a client wants to carry out alteration or works to the property, then the position is that the client should be told about the current planning status, and if the client wants advice or assistance with regard to the planning applications or works that need to be done in order to obtain planning permission, then that would be a matter that would be out with your retainer. What is in the retainer and what would be necessary for you to give advice on to a client would be the position with regard to rights of way or property access. In an ideal world, we'd want our property to abut the public highway. If it doesn't, and if we have an independent private right of access, then we need to know what the extent of that access is, and we need to know whether or not those rights are sufficient or adequate to enable our clients to enjoy their use of the property. And we also need to think about repair and maintenance. Be particularly careful where our client is buying a property and there is a private access to the property, a private road, or private paths or something of that nature. Do we have a legal easement? Do we have a legal right to use the path or the road? for the purposes that we require. Has that easement been registered if it's a legal easement? If it is a prescriptive easement, have we got evidence to support what the prescriptive right extends to? If there is a right-of-way described in a conveyance or a transfer, is there a plan that indicates the route of the right-of-way or shows it on the plan and the description of the right-of-way are consistent with one another? Item C, and failing to check plans to ensure the whole property is included in the sale. Again, this is not an uncommon problem. What you should be doing with a client is when the client inspects the property, you should be providing the client with a copy of the title plan with a health warning that they can't rely on that plan. You should be providing the client with a description of the property and the estate agent's particulars, and then telling the client that the client should be checking what they see as against what is revealed by the plan that you've provided and how the property is described. So I'm your client. I'm going to inspect the property that I'm buying this afternoon. You're going to give me a copy of a title plan with a warning that I can't rely upon it. You're going to explain to me how the property is described in the contract and in the property register, and you're going to give me a copy of the estate agent's particulars, and you're going to say to me, inspect the property and check that the plan and the description are consistent with what you see. Other issues that can cause problems, boundaries, particularly where boundaries have moved or where there's been adverse possession claims or boundary or neighbour disputes. Failing to spot defects in title, always audit a registered title. Is this an absolute title? If the title is unregistered, am I comfortable that the title, although unregistered, can be subject to an application for first registration and the application for first registration will succeed? Failing to carry out searches or advise about the content of searches. Important, there's no such thing as usual searches. There are essential searches. There may be necessary searches given locality, etc. The important point here is, with regard to searches, the client needs to be aware of what searches are essential, and you should be advising clients as to what searches are usual or necessary given locality or given transaction. And Barty and her colleagues can provide you with guidance and expertise with regard to which searches might be appropriate given location or given your client's purpose. So, for example, if your client's buying a property in an agricultural area, it may be appropriate to undertake some form of agricultural search. If your client is concerned about subterranean activity, then it might be appropriate to do a geological search relating to the property. There's all manner of different searches that might be appropriate given location and given client objective. Going on from that, there are other things that can cause problems and can cause claims, such as, we'll just go to the next slide if we can, the TA forms. And failing to advise a seller as to how to answer the TA forms. We've got, of course, a revised TA6 form, and I would urge you, if you haven't already, to look at the revised TA6 form and to think about how you're going to revise your retainer and your report on title given the revised TA6. Remember, the revised TA6, it becomes live and operative in March 2026, but there are some firms that are using the revised TA6 now, and therefore, whilst your firm might not be using it, you might be receiving contract packs or bundles with the revised TA6. In those circumstances, it's important that the retainer with the seller is altered or a retainer with the buyer is altered so the client understands the implications of this new form. Co-ownership is a form of claim, a common form of claim. If you're acting for co-owners, you need to do two things. One, make sure you get as much information from the clients as to their circumstances. Two, give advice to the clients about the choices that are available to them. I would hope that everyone that's attending today has a co-ownership questionnaire that they use or dispatch to their clients so that they can extract from the clients the information that's necessary to give advice relating to co-ownership. If you haven't got that questionnaire, if you ping me an email at the end of the webinar, I'll happily send you a copy of a questionnaire that was devised some years ago by a barrister friend of mine. Failing to obtain trust deeds to reflect agreement between the parties where we're dealing with tenants in common, again important. And equally important, a failure to advise clients about the need to keep trust deeds up to date, where the extent of a beneficial interest alters during the ownership period. Again, sounds ludicrous, but it causes claims. Failing to ensure that legal mortgages or equitable mortgages are paid off upon completion and that undertakings are complied with. Item K, property fraud is still an issue. Money laundering remains an issue. All our professional bodies are hell-bent on ensuring that we comply with anti-money laundering legislation and that we have anti-money laundering policies in place and that we comply and adhere to those policies. SDLT causes problems. A few things here, really. Important that you have an awareness of reliefs and surcharges that apply, and that you're also aware that the online calculator that's produced by HMRC doesn't deal with all the reliefs and surcharges that are potentially available. SDLT can be particularly complex in residential transactions, and it's important to appreciate that you can seek specialist advice where appropriate. It's also important to ensure that where you are undertaking SDLT calculations, that someone in your office or an external third party checks your calculations, and that a further review is undertaken before exchange of contracts and before completion. Acting without authority or instructions or where there's a conflict of interest again causes claims. If someone sustains loss and we have failed to comply with the standard of a reasonable conveyancer, then we're potentially going to be in the firing line for a negligence claim. Absolutely essential. We understand and appreciate that. So that gives us a flavour of the sorts of things that can cause claims. And you're going to be saying to yourself, well, Ian, that's fantastic. What can we do to stop claims arising? And that's what we're going to talk about next. This case is really interesting. And it's really interesting because the firm of solicitors was sued in negligence. Their client, a lady called Miss Harry, contended that her conveyancing solicitors were negligent. They hadn't given her advice in connection with the plan of a local authority to construct a link road near to her property. That link road, when constructed, would cause noise and nuisance, and she was of the view that her solicitors should have told about this apparent intended construction during the conveyancing process. She lost her claim. And the reason she lost her claim was she had trawled the internet and found a firm in her locality, the defendants in these proceedings, that would provide a basic conveyancing service at a basic fee. She was very happy to find someone that would offer a conveyancing service as cheap as possible. The lawyers concerned had been smart and had drafted a retainer which explained what a basic conveyancing service involved, and also explained to the client that it was possible to get a better, more usual service that the firm was happy to provide at a greater cost. Miss Harry chose the basic service and was aware that the expectation was that she would get a basic service provided by the solicitors because she was paying a basic fee. Had she chosen the usual or normal fee, then the firm would have investigated activity within the vicinity of the target property. As it was, the basic fee meant that a basic local land charges search and inquiries of local authority would be made, and the search and the inquiries and answers to inquiries would not have revealed this proposed link road and its likely completion and the effect on the property as a consequence of it being completed. So the firm escaped liability, and the reason they escaped liability is that they'd scoped the retainer. Miss Harry was aware of what the firm was doing, but also, significantly, she was also aware of what the firm was not doing, and that's so important. So again, if we look at what we can do to avoid negligence claims, in particular with regard to due diligence, setting realistic client expectation, understanding client objective, and then making sure that we tailor our due diligence to ensure that objective is achieved, to make sure the client understands that we will endeavour to ensure that they are protected with regard to that objective. But the client needs also to understand that the conveyancing process does not provide us, if we're acting on behalf of the client, with a magic fix to every conceivable problem that could arise during that process. So we need to set realistic client expectation and give the clients examples of what they might think that we ought to do that in fact we won't be doing. So let's just talk about that for a second. The first thing that's a great example of setting realistic client expectation is the issue with regard to plans and boundaries. The conveyancing process, traditional plans title plans, etc., will not reveal legal boundaries. A legal boundary is, in essence, a pencil line that separates one title from another. And the moment that we start putting a pencil line on a plan, a land registry title plan, an ordnance survey plan, or anything of that ilk, the pencil line that is in fact the legal boundary becomes 1.5 meters wide and becomes a problem as a consequence. So clients need to understand that. Clients need to understand that we won't be inspecting the property. We won't be advising the client about the commerciality of the transaction. We won't be advising the client about a survey or valuation. We won't be advising our client in a leasehold transaction about service charge accounts, etc. So explaining the limitation of our instructions, explaining the limitations of due diligence is important. We're very good, I think, at telling clients what we're going to do. I'm not particularly comfortable that we're good at telling the clients what we're not going to do, and we need to do that. Which leads me on to the retainer. The retainer is a critical document, and it should be a document, we should always have one, that's given to the client at the start of any conveyancing transaction. And in it, we can, as we saw in that case earlier of Miss Harry, we can reduce or limit potential liability to negligence. We can highlight the work we're going to do and highlight the limitations of the work that we're going to do. And we can also indicate to the client work that the client might expect us to do that in fact we won't be doing. The client might think we're going to be inspecting the property. We're going to be giving the client advice about the state and condition. We're not going to do that, and the client needs to understand it. Going on a little further in connection with the retainer, it must be in writing. If it isn't, then the court will suggest that the retainer is implied, or anything that's said to the client or by the client would constitute some form of oral retainer, and the problem there is evidence. If something's not reduced to writing, what has been agreed, and often, the court will have a problem. There must be a written retainer that's provided to the client at the start of the transaction, and the retainer must be clear as to what's being done and what's not being done. If it isn't, if it's vague or ambiguous, the document will always be construed against your firm that created the document and in favour of the client that's relying on it. Once we've created a retainer and our client has read it and agreed it and understood it and signed it, then we need to be concerned about this second bullet point, the concept of monitoring the retainer. Something that professional indemnity insurers are really worried about is a situation where there is a retainer and then you do something over and above that which you said you were going to do within that document. It is absolutely essential, if there is a retainer, you do that which the retainer requires you to do and nothing more. If you are going to do additional work, you need to expand the retainer, and that should be some form of written document or email. And you also need to think about whether the client should be charged for additional work that you're doing. If you're doing additional work but not charging the client for it, it's important that the client is aware that you're doing the work and there's no additional cost. But I would prefer it if you tell the client you're doing additional work and you're charging for it. Important that the retainer is considered, amended, and subject to review. A number of things really that I think are really, really important. Firstly, and significantly, as far as the retainer is concerned, the client has to read it, has to understand it, and has to sign it. Going on, if I may, some tips for you. A retainer can limit the extent of your duty, but no matter what you say in the retainer, you're required to do things. Second and last bullet point on this slide. You are required, notwithstanding what you say in the retainer, to proffer advice that's reasonably incidental to the task in hand, and you're also obliged to report and advise upon anything that might be materially adverse to the interests of the client. What does that mean? If you're acting for a client and you've said you're not going to do something, but you become aware during the due diligence process of an issue, even if you said you're not going to deal with it, you need to draw it to the client's attention. So I'm not going to give you advice about the state and condition of the property, but I am aware, looking at a TA form, that the seller is saying there's a problem with the garage roof and the felt needs replacing. In those circumstances, you should report that to the client, even though you said in the retainer, that you wouldn't be dealing with state and condition. You're aware of something that is materially adverse to the interest of the client, and therefore it should be disclosed to the client. Very important point indeed to understand and appreciate. The next thing I want to talk about are searches. And in the issue of due diligence, this is something, of course, that's very close to Barty and Whitefield's heart, because this is their business. But there's some points that I want to emphasize if I can. First of all, in a conveyancing transaction, there's no such thing as usual searches. I repeat the mantra that I mentioned to you earlier. There are essential searches, local land charges search, inquiries of local authority, drainage and water search, environmental search. There are necessary searches, climate change report, perhaps additional inquiries of local authority, and necessary searches might be searches necessary for locality, coal mining search, gypsum searches, radon searches, tin mining searches, you know the drill. Where you get searches back, it's not enough simply to give the client a copy of a search and say, read it. It's necessary to indicate to the client what the search reveals and to highlight any adverse entries or any issues that generate risk and draw to the attention of the client the existence of that risk and what can be done to identify it or mitigate it. It's important, I think, that clients understand the limitations of searches. For example, a local land charges search is property specific. It doesn't carry any form of priority, and therefore it may be necessary for the search to be refreshed or updated before we exchange contracts. As far as an environmental search and report is concerned, it will contain quite sophisticated information that we as solicitors or conveyancers can't advise our client on. So if there are issues with regard to an environmental search and report, I would normally suggest to the client that they go direct to the report provider for guidance and assistance with regard to content. The next thing that I think is really important with regard to due diligence is the issue of client inspection. And I think this is frequently overlooked in advising clients as to what to do and reporting to the client in a report on title. Your client should be told to inspect the property they're purchasing before exchange of contract. The client should be told what to look out for: persons in occupation, any evidence of any form of third-party right that appears to be in existence. The client needs to understand that with regard to inspection, the client is bound by anything that they actually see or that they're actually aware of during the inspection. They're also bound by anything that they ought to see had they undertaken a reasonable inspection. That's the concept of constructive notice. They're also bound by something called imputed notice. If they instruct a third party to inspect a property on the client's behalf, then if that third party becomes aware of something, the third party is deemed, his or her knowledge is deemed to be binding on the buyer client, whether that third party has told the client about what they found or not. So it's important that the client understands that when they're inspecting the property, they're obliged to undertake a reasonable inspection. And it's important that the client understands what a reasonable inspection is. Inspecting all the rooms, opening the doors to all cupboards, inspecting the cellars and attics, gardens and grounds, and any buildings within them. It's also important to identify who's inspected the property. If we're acting for co-owners and one of them's inspected the property, then what they become aware of is theoretically binding on their co-purchaser or co-buyer. Clients should be inspecting before exchange. They may need to inspect at exchange if the property is empty or if we're worried about vandalism or damage to the property. And the client should also inspect at completion if they're not moving into the property. But here I'm really worried from a due diligence perspective. I'm really worried about the client undertaking a reasonable inspection as part of the conveyancing process and reporting back to us what they see in that inspection. So the next thing I want to talk about are some good habits. As we've just explored, identifying client objective, scoping and managing the retainer. Third point we haven't mentioned yet, front-loading the client with information about the conveyancing process, about the documents they're going to encounter, the significance of that documentation, and our role. I think where we can, we should use external resources such as the RICS Consumer Guide to Survey and Valuation, the Leasehold Advisory Services guidance on owning leasehold property, etc. And I think clients need to understand the limitations surrounding due diligence. The fact that the due diligence process is not a perfect process for finding out the property that's being acquired. Things like client inspection, survey, or valuation are just as important as the work or tasks that we do. So now that we've sort of discussed the sort of general proposition, let's have a look at some of the sort of particular issues that I've mentioned and see if we can again provide some helpful information for you as part of the due diligence process. And the first thing in that connection is issues associated with boundaries. Whenever you're acting in a resi transaction, you should always attempt to identify if boundaries have altered or moved, or if there's any boundary sensitivity with regard to the acquisition. So when was a boundary created? Has it moved or altered? And is it clearly identifiable? And remember, a legal boundary is a pencil line. So if the boundary is a boundary fence, somewhere on that fence, somewhere within a fence post or a fence plank, will be the legal boundary. And often it can be difficult to establish just where that boundary is. To identify a legal boundary, we're looking at what was intended when the boundary was created. In an ideal world, that boundary will have been created in a conveyance when a parcel of land was sold off, and that conveyance contains a clear description as to where the legal boundary can be found. That document may well be accompanied by a plan, and that plan needs to be consistent with the description. So plan and description, assuming there's both in the same document, should correlate with one another. Problems can arise if they don't. The next thing that we need to watch out for is, could the boundary have altered since the date the boundary was created? And here we've got to look out for adverse possession claims, or we've got to look out for boundary agreements or determined boundary applications that have been made to the land registry. These cases that are shown on this slide, I don't have time to take you through them, but in short and put simply, they indicate that a land registry title plan does not reveal a legal boundary, and that to identify a legal boundary, it's necessary to ascertain what was intended when the boundary was created. The sort of source document, the conveyance, the transfer, the contract that established the boundary. If we've got that and it's clear where the legal boundary is, our job is done. The next slide that I want to show you is this one. There are a number of useful resources for dealing with boundaries, Land Registry Practice Guide 40 being a starting point. The textbook Emmett and Ferrand on Title, Chapter 17, again, contains information relating to boundaries. Something you may not be familiar with, the RICS has a boundary procedure for boundary identification, professional standard, which you can look at. And then the Property Protocols website